Excuse me?
Why is it effective at midnight?
Because we had this emergency request, which we made to them. Why Erica.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixing Housing 401k plan.
Donna Tope on behalf of Erica Ward and Aaron Ward. Tenants.
Your Honor, I believe my client, Griffin Hawk, I think I see him right now. He's on Zoom. He couldn't attend today.
All right. Yes, what is your name, sir?
Me? Griffin Hawk.
Yes, sir. Say again.
Griffin Hawk.
Yeah. Okay. All right.
A landlord hasn't been paid in months. Tenants claim emergency repairs and retaliation. Now the judge must decide who's playing the system and who's telling the truth.
Your Honor, we're here for our fourth pretrial hearing. If you recall from the last hearing, you adjourned plaintiff's time to seek alternative counsel.
Right.
It appears that they used that time to file a dispositive motion and an omnibus motion for repairs and Ms. Tope's motion for withdrawal 2 days before this hearing, which I received a copy at close of business on Wednesday, which forced Landlord to file its own MSD, which was filed with the court this morning. So it appears it is further delay by Tenants, and it's another month with my client not receiving any rent payment for his property.
So I can just tell you what I agree with everything that you said. I can just say from the court's perspective, because of the way that my docket is, I did not see these various motions actually until late yesterday, but I have a life. So it was really this morning that I saw that, and then I saw your motion came in.
Yes.
And I have that.
Your Honor, I brought a hard copy if you needed one.
Of your motion?
Yes, Landlord's MSD. You got it? Okay.
I got it.
Good.
Okay. So, Ms. Joe.
Yes. I filed judge's copies for you that had the tabs attached for the 3 motions for repairs, one of which is an emergency, and that's why things were delayed in getting the motions to you. I also filed a motion for my withdrawal, and I gave the underlying theory that the tenants have agreed with, and that is ready for your signing. I attached an order at the back of that, and then I filed, and it's effective midnight today because we had the emergency request for repairs that was made a week ago. And we filed a motion for dismissal with prejudice and damages based on retaliatory eviction.
Anything wrong with all of that?
Your Honor, I know you have expressed several times your not order and not opinion, but your advice that my representation of the wards somehow is ethically compromised. But I have tried each time that I have appeared before you and you have expressed your concerns, I have tried to give you the underlying basis for why I represent them and how I have conducted myself in that representation, including today. And that is in my motion, the underlying legal basis, and it's on Exhibit 1 at page 5, and it says that a bank account or other account held by a third party generally established in the name of the tenant into which whole or partial rent deposits are made to show that the tenant was ready, willing, and able to pay the rent, but is withholding the rent until a certain problem is fixed. And that is exactly what Erica Ward did. The money was not held in a legal IOLTA account.
Which might be part of the problem.
And you say might.
You can't do both.
Okay.
Counsel.
Okay. I agree. My clients and the plaintiff do not need to spend any more time with your concern with how the money was held. I have filed a withdrawal. They have agreed. They are perfectly able, competent, and know everything about this case and are wanting to exert their right to represent themselves. And that's what this motion says. So they signed it. It's a stipulation, and I've signed it, and I have the order ready for you.
So are they really? So if that's the case, then why is this effective at midnight?
Excuse me?
Why is it effective at midnight?
Because we had this emergency request, which we made to them. Why Erica, made to them to fix electrical fixtures in the residence that are used for auxiliary heating, which in this temperature weather is essential for the safety of the residents, and the outdoor security lights, which have gone out, and with the unsafe conditions out in the driveway and the walkways, those are essential. And the plaintiff refused to reply, refused to make the repairs. And so that, knowing that we had this hearing today, that is one of the motions, motion number 3, which is requesting permission for the defendants to make essential minor or electrical repair, which the plaintiff has refused to address, and to deduct the cost from the rent on January 1st.
You can't have it both ways.
How
You can't have it both ways.
Then I would ask that you recognize that the wards made that request of the plaintiff, take me out of the picture, and they did not reply. And if you would like them to stand up here and say exactly what we say.
Are they going to be able, folks, are you going to be able to give me the legal arguments that are necessary?
Legal arguments? I
Yeah.
have to state the facts.
Okay, but you understand that I would be taking facts as I found them, applying a legal standard to that and making a decision. You understand that? And are you prepared to make the legal arguments?
I guess I don't understand that.
I understand your question. I think we're in tough.
So what's the answer?
Yes, we are. We'll do the best we can. You know, we have a business that doesn't make any money. The attorney fees would be.
Sarah, I get it, but I also can't.
It's a tough situation. I
Pardon?
understand your question. So yes, we'll do the best we can. And it is what it is.
Let me ask this. The conditions that are complained of, how long have those existed?
So
The electrical outlets.
the electrical outlets on the outside I've only noticed as of this winter. They were working fine.
So how does this become an emergency motion?
Because the water freezes and then
No, I get that happens in cold weather. I understand
I
that.
have to use water heaters.
Okay, but I guess maybe I'll ask this. You're asking me to address this as an emergency motion where the court has only had an adequate opportunity to.
In court, timing is everything. You can't claim emergency while rewriting the rules at midnight. When strategy replaces honesty, the judge sees right through it.